Hi, welcome to Victim to Victory, the authority in personal injury. My name is Lawrence LeBrocq. I'm the managing partner of Garces, Grabler, and LeBrocq. Here today we have our top workers' comp attorneys, guys that we cannot call experts because it's ethically improper, thank you, to say that, but they have handled well in excess of 10,000 clients. It's an amazing amount of work that these gentlemen have done in the field of workers' compensation, and they've forgotten more about workers' comp than I even know. So I'm going to introduce them from my right to my left. We have Victor Broccoli, and my partner next to him, Bill Grabler, in that beautiful green jacket. He's been doing personal injury law for 40 years. And to my left is Mike Tomasino, another incredible young workers' comp attorney. But young does not mean inexperienced. This guy is a beast in the world of workers' compensation. So guys, let's start out and let's just talk a little bit about the difference between workers' compensation and personal injury or third-party litigation. First of all, Bill, I'll just ask you simply, what is workers' compensation, and then what is a third-party case that could originate or emanate from a workers' comp case?
Workers' compensation is a system that the state of New Jersey has set up for people who are injured while at work, arising out of and in the course of your employment. Those are the statutory words to remember. It's a system where the insurance carrier, the workers' compensation insurance carrier, is supposed to provide medical treatment to an injured worker. They get the right to furnish that treatment, which means that you're going to a doctor that the insurance company is telling you to go to. New York, Pennsylvania, you can pick your own doctor. New Jersey, you're going to the doctor that the carrier wants you to go to. If a doctor says you can't work and you need treatment, you'll be provided temporary benefits, 70% of your gross weekly wages, and then you have a right to go to court to receive money for any permanent disability that you may have as a result of your accident. Those are the essential rights that you have in workers' compensation. A third-party case is one where if your injury happens during the course of your employment, arises out of your employment, and is also caused by the negligence of a third party, which means not your boss, not your co-employee. Easy example is if you're an Amazon employee, let's say, or you're just driving a car, let's say, in the course of your employment, and you get rear-ended by somebody. Clearly that other person's fault, and that person is not a co-employee and not a superior at the company where you're working. You have a workers' compensation claim, and you also have a, quote, third-party claim, a negligence action, personal injury action against the driver of that car that was negligent and that caused the accident. That's basically a good rundown of what is a workers' compensation claim and what is a personal injury action. The thing about our law firm, Garces, Grabler, LeBrocq, GGL, is that we have lawyers that handle the workers' compensation claims and handle the personal injury claims. So it's a one-house for any client that both of the cases can be handled at our office, and handled very well, because everybody knows what they're doing.
And the interesting part about our office, as opposed to others, is nobody at our office is a jack of all trades. The guys who do and gals who do personal injury do nothing but personal injury, and the men and women who do workers' compensation law only do workers' compensation. So although you can't say you're a specialist, they specialize in a particular field of injury law. So Mike, I'm going to ask you about, just talk to us about how one qualifies for a workers' compensation case and what shouldn't they do or should they do if they're injured on the job?
Absolutely. So you qualify if you've been injured within both the course and the scope of employment and if you've suffered a permanent injury. So the course of employment, you're at the job. The scope of employment, you're doing something to further the work function, opposed to being on lunch, smoking a cigarette, things along those lines. And the third criteria is you have to have a permanent injury. There are a lot of pitfalls that you see, some by the individuals that are injured and some by the lawyers. Okay. Initially, if you've been injured at work, the first thing that you want to do is report the accident. You want to report the accident immediately to your employer, and ideally, you'd like the employer to draft a report documenting the accident's occurrence right when it occurs. One of the things that we see often is people will go to the emergency room. They'll speak with their employer, and the employer will say, don't tell the staff at the emergency room that the accident happened at work. In the event that you get medical treatment, especially on the day of the accident's occurrence, you've got to be honest with the doctors. If you go to the hospital, you have to inform them it happened at work.
And why would an employer tell an employee to say they weren't injured on the job or not to say they were injured on the job?
Well, there's a couple of reasons. I always imagine that the employers either want to immediately terminate the person opposed to providing them with the rights that the injured worker has, or sometimes the employer's afraid. There are a lot of times people are working off the books. They may not be legally in the country, whatever it may be, and the employer tries to shift the burden away from them by having the injured worker lie.
Now, Vic, what happens now if somebody is working on the job and the employer does not have workers' comp insurance? Then what happens?
Okay. Well, if they don't have workers' comp insurance, the case becomes a little trickier. It really depends upon what the employment situation is. For instance, sometimes what we look at is, let's say we're talking about a construction site. And the uninsured employer is, say, like a subcontractor. What we'll look to is, let's say there's a general contractor that does have insurance. We'll look to find workers' compensation coverage through the general contractor or a different employer that there might be an employer-employee relationship. It's kind of a case-by-case determination. In other cases, we'll look to something called the Uninsured Employers Fund as kind of an insurance fund of last resort, but it's really a case-by-case determination if the employer doesn't have workers' compensation insurance.
And I would just note on that, in New Jersey, the state has a database, unlike other states, that documents each employer's insurance, so it's very easy. You can just search the name of the employer. Most times in under 30 seconds, you can learn whether or not they have insurance. Anecdotally, I feel probably 98, 99% of the cases that I have are cases where the employer has insurance, even if the employer informs the injured worker that there is no insurance. Most of the time, there ends up being insurance.
Yeah, it is against the law in the state of New Jersey to have a business that doesn't have insurance. I'm going to agree with Mike, though. Most of the people that walk through the door are working for places where there is insurance, and I will say that the uninsured employer fund, which Victor talked about, the UEF as it's known, is a disaster, and I'm going to say that. I don't care because it is. I used to handle uninsured cases, and judges used to thank me for doing it because it was such a pain in the butt to handle those cases. Our law firm doesn't handle uninsured cases anymore. We refer them out, but the problem with referring them out is that you can't even find people that want the cases. They're that hard.
So what are the main reasons that an insurance defense firm in workers' comp denies claims?
There are many. So, one, New Jersey, unlike other states, lacks a bad faith statute. What that is a series of laws that punish the insurance company for wrongfully denying claims. In a workers' compensation claim, there is really no true recourse that is suffered by the carrier or the employer for denying the claim. So just generically, if I was defending a case, I would file a denial on every claim because you can always switch the denial later to an acceptance. Strategically, it makes sense to deny all of the claims.
Why? Why?
Because there's no penalty for them not doing it. For example, if the carrier accepts the claim, they begin providing the injured worker with medical treatment and then also money, temporary disability, which is 70% of their gross average weekly wage. That begins on day one. Whereas if you deny the claim, you can delay the treatment and the money and potentially not provide it at all. A lot of times, workers who don't retain an attorney will just let the claim go if the carrier or the employer denies it. Many of times I see clients, we take a lot of cases over from other firms. Okay, the insurance carrier's attorney denies the claim, maybe rightfully, maybe wrongfully. And what happens? The lawyer that the person retains doesn't forward them for medical treatment. And in turn, the case lingers on for years, 3 years, 4 years, 5 years, and the person receives no money for the time out of work, no medical treatment, has bills from, say, an emergency room visit, and the reward at the end of the case is some measly $5,000, $10,000 settlement. So back to your question, it makes sense for the carrier to deny the claims because it puts the onus, the pressure on the injured worker and his lawyer to go out and to send the person for medical treatment and to begin the process in court.
Victor, what would you say?
As far as deny,
I'm the old guy here in this department at this table. Yeah. So I'm kind of interested in hearing, and I don't mean to take over, Lawrence, but I want to hear the other young workers' compensation attorney to my right, and I hired both of these guys, and they're both great. But I want to hear what you had to say, because I have my own thoughts, but I want to wait till I hear the other young guy give me his thoughts on why these claims are being denied.
So to piggyback on Mike's point, when you have denials like that, it does put the onus on the attorney, and really I think that what really differentiates our firm is that we're really good and really aggressive on those cases. We build them up from day one. Our denied cases and our approach on them, I think, really differentiate us from other firms. We're really good on those cases.
One of the things I would
Hang
note...
on 1 second.
Okay.
You talked enough already, right? That's what I wanted to hear, Victor. There are more reasons for why they're denied, but here's what I wanted to say, the old guy here. I've been doing this 42 years. Back in the day, 10 people would walk through the door, 8, 9 of them had admitted claims. They were not denied the way they are today. Does that mean that employers were nicer, kinder, more honest before? Maybe. Who knows? But all I know is the climate has changed dramatically. There are a lot of denied claims now for various reasons, one of which is what you've heard from these two guys. Other reasons may be that there's a lot of bad employers. We're talking about bad carriers. How about bad employers? They're out there too. And they're not talking to the carriers, because some carriers are actually pretty decent about admitting liability and providing treatment immediately. What I'm glad that I heard from Victor is that our firm is excellent at being proactive, aggressive. It's GGO wins. That's what we advertise, right? You know what? We do. And the reason we do is because we care so much for our clients. We fight for our clients from day one. As Mike said, if you're not fighting for your client from day one, your client, is going to have a lousy claim that is worth very little down the line. If you fight for your client from day one, what you're doing is you're looking at this as an opportunity. This is what this is. If the carriers want to play mean, dishonest, stupid, whatever word you want to assign to it,
34, 15,
all
15.
it means is that I can now send my client to a doctor who I know. My doctor's going to treat that client. I'm going to file a motion immediately, and I'm going to go to court, and I am going to look like a hero to my client, because I am going to get my client medical and temporary benefits, and guess what? I get a fee on that. So carriers, if you want to be this way, continue to be this way, because I am going to continue to fight for my clients and do a great job for my clients. That goes for these two guys here, too, and my entire firm. That's what we're taught from day one. Any lawyer coming into this office, I talk to them. We're all raised this way. It's the way we're all taught what we have to do. Be aggressive and fight for your client.
Since I've been at the firm, I joined in late 2018, I've recovered in excess of $80 million just in New Jersey workers' compensation cases. 50 to 60 million of that group is on denied cases. When we meet with the client, when a client comes in, the very first day you meet with the lawyer, if you haven't been sent for treatment, we send people for treatment. Many other firms choose not to send clients for treatment in denied claims. We are distinguishable from everyone else because we send people for treatment, and we have teams of physicians that we use, specialists, subspecialists, any sort of injury that you can possibly have. We have seen it, and we have doctors that we can refer you to. at the inception of the claim.
Yeah, we do a great job at this. I'm proud to say this. And I don't want to beat this one subject to death because I know, Lawrence, you got a whole bunch of other topics, but I'm going to tell you. There's a guy that called me. I had a Zoom meeting with him the other day. Nice guy, a little crazy, but he's a nice guy. He's got 2 cases, and they're both worth nothing. They are horrible, nothing claims. The accidents happened a year and a half ago. How much treatment did he get? 0. And his lawyer, a year after the accident, sent him to a forensic expert who says, yeah, the guy needs treatment. Nothing has happened. I've got 2 files right now that, frankly, I wish I didn't even have. But I am going to try to do my best and help that poor guy because he's got 2 claims. He went to another lawyer, and nothing got done. And that's what Mike was talking about before. If your lawyer does nothing, your case is going to be worth nothing.
And that's because it's so much work to file the motion and to be intentional about trying to get a client paid. It's very similar in the world of personal injury third-party litigation, where the insurance company's saying is deny, 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 and hope they die. It's the same thing they're doing here. Just keep denying and hope they go away.
Yeah.
And whether they die or they just don't pursue the claim, that's what they're hoping for. So we're talking a little bit about medical and denials. So let's talk a little bit about what happens when a doctor, of course, it's a defense doctor, because all the petitioners have to go to the defense doctors in workers' compensation, says your client reached maximum medical benefit, or MMI. So what do you do if your client is still having severe pain, but yet the defense doctor says you've reached maximum medical benefits?
So, again, it's on my end. It's you talk to your client, you get the records in, and we talked about on the denied cases the ability to send your client and set up treatment on the denied cases. We benefit, again, from the network of experts that we've cultivated over the years. We can send clients to second opinions with specialists for those second opinions. And if we have a client that the imaging and the objective medical evidence suggests and that they're in pain, that they're not doing particularly well, we can set up second opinions with experts, and that allows us the ability to go to court and to file motions and to fight for our clients.
And I would just note on that, Victor's answer is contingent on the client getting diagnostic imaging, which doesn't always happen. The more common one that I see is the client goes to a doc in the box, a Concentra, an urgent care, whatever it may be. They go for a week, they go for 2 weeks, and then the treatment halts. They don't see a specialist, there are no MRIs. In those instances, it's almost like we have to build the case from the very beginning, the inception, as if the client didn't go for treatment at all. We've got to send them for physical therapy. We want to take an MRI and have it taken on a high-resolution machine. And then once you have the MRI for the first time, you know what's wrong with the client, how you can help them, and then which experts they have to be sent to thereafter.
Yeah, I like that doc in the box description. I tell my clients it's not a bad place to start because it's usually where a lot of these cases start. You named a few of the places, but it's not a good place to end. I want all my clients to be seen by specialists. I want my clients to get MRIs, and that it does 2 things. Number 1, your client is actually seeing somebody that can help him, treat him or her, and you're also increasing the value of the case. If it's a serious injury, the specialist and the testing is going to provide objective evidence that it's a serious injury. If you've got a client that just went to an urgent care, City Med, Med Express, whatever they call the place, and has nothing more, you've got very little evidence of any value to that claim, any real injury there.
So when you get your clients out for all the treatment they need, they have all the procedures that the doctors are recommending and they want to have, then how do you make a determination on, are we settling this case or are we going in front of the tribunal to make a decision on the case? How do we make those decisions?
Who wants to field that one?
I'd almost allege the carrier makes the decision for me. They're either going to pay an amount that I deem is reasonable or they're not. And if they don't, we end up in front of the tribunal at a trial. So we try and work up the case by sending people to at the end, after all of the treatment's concluded, you have to send the person to an IME doctor, essentially an independent medical expert. I see a lot of the carriers and even some of the other petitioners' attorneys send people to kind of amorphous physicians, people with no real expertise, who merely write these reports and perform these examinations. At our firm, we try and have credentialed doctors in that specific area write the reports, people who are real surgeons, and it helps us negotiate the case in order to put it at a point to where the carrier is now forced to pay an amount that we deem fit. But if they don't come up with an offer that we believe is reasonable, then we go before the tribunal.
What do you say, Victor?
Yeah, that's
Same
it.
thing?
Yeah, it's the same thing. You know what the cases are worth. You know what the value is of it. I will say that to dovetail a little bit on that, as far as kind of knowing the value, in addition to the medical evidence, the objective medical evidence, I do talk to my clients prior to making a demand. I do want to know functional loss. I do want to know impact on employment, because I do think that those are levers outside of just the medical reports that help me drive value to the case. But at the end of the day, that helps me know this is what the case is worth, and they're going to pay it, or I'm going to try it.
Yeah, these two guys have said exactly how I would start my answer to that question, which is know the value of the case. If it's offered early, so be it. The case goes away early. If it's not, then it proceeds longer. But I think that in order to know the value of the case, you have to know your client, you have to know the file, and that takes work. What Victor said also is beautiful. The way it works in workers' compensation, Mike touched on this, is that the person is going to treat, the active medical treatment is going to end, and then you're going to get all the medical records, and the petitioner, they call them, the injured worker, is going to be seen by a forensic expert for him or herself, as well as for the insurance carrier. And you exchange these reports with the other lawyer. And then you talk to the other lawyer. You make a demand. You get an offer. If you can resolve it, you resolve it. You may need to get a judge involved. I almost always get a judge involved. And that leads to another question, to another consideration. You have to not only know your client, not only know your file, you have to know the judge too. And in terms of knowing your client, I do the same thing. What Victor said, I loved hearing it. I meet every client. I don't care if it's a finger case or if it's a catastrophic back with 5 surgeries, it doesn't matter. I'm meeting my client just before I start talking to the other lawyer about settling a case. I talk before I see that judge. And I will tell you that there have been many conferences where recently a judge would ask me, Bill, I think the value is this. Why do you think it's worth more than that? And I said to him, Judge, I'm glad you asked that question, because I talked to my client this morning, and here's the deal with my client. And the judge heard what I had to say about my client and said, Bill, thank you. I agree with you. It is worth more than what I thought. That's how you do it.
Right. And what you may not understand if you're watching this show is that in workers' comp, you're in front of a judge. There is no jury. It's not a judge and jury system. The tribunal is a judge that specializes in workers' compensation and sits as that judge. So the judge that's conferencing the case is the same judge that's going to determine the value of the case if you should try the case.
Let me add one thing. Sorry. I can't tell you. I wish I had $1 for every time a client said, I'll take the offer. And I said, I'll get back to you. And then I got him more money by presenting his case to a judge. I didn't do anything wrong, okay? Nothing. If a client tells me take it, I'm going to take it, okay? But I'll say to my client, hey, look, I get it. You think this is good, but I'm telling you, I know what I'm doing. I'm going to have a conference tomorrow. Can you wait a day? Client will say, yeah. And then I'll call my client back the next day and I'll tell him I got him $20,000 more, okay? Because we know what cases are worth. We love our clients. We'll do what our clients tell us to do, but sometimes they're their own worst enemies because they're in a hurry. And sometimes, all the time, actually, we're their best friends because we're looking out for them.
Some defense tactics that, you may have an employer or defense lawyer claiming that your client is exaggerating their injuries. How do we deal with that?
To a certain extent, I think that's just, I just think that's a little bit of BS. I see it enough where I will just dismiss it as fluff. And what I mentioned like a few minutes ago, if we're in kind of that settlement negotiation stage, I will talk to my clients specifically about what they're doing, the activities of daily living, and their work. Because I really think that what you're doing for a living really bears out in how much this injury affects you. It's one thing if maybe you're in front of an IME doctor and this is what you're saying in a particular report. I think it's another thing if in how you act in your actions as far as your participation in the workforce, because everyone has to eat, everyone has to keep a roof over their head, everyone has to keep the refrigerator filled. So if somebody is genuinely unable to work or unable to keep their to what their wages were pre-accident or participate in the workforce to the same extent that they were, and they're struggling in their ability to keep a job or keep a job full time, I believe them, and I'm able to tell a judge that. So if just because, a defense doctor is going to say, oh, this person's exaggerating, but they're not able to work in a warehouse full time, or they've got to take a lesser paying job because they can't work to the same extent, I'm able to say that and argue that, and most times I'm going to be successful because of that. So again, I think it kind of gets into, I've got to know my client, I've got to know their matter and know their file, and that's how I'm able to overcome it.
So it really comes down to credibility of the client as opposed to the
Yeah.
credibility or lack thereof of a respondent or defense doctor.
Yeah, I think it gets into knowing the file.
And I also view it as both an art and a science. The artistic portion is what Victor's talking about, being able to go in and articulate these kind of personal circumstances. An individual returned to work, but they work less hours. Or now they're at a new job and they make less money because the job isn't as demanding as the one they had prior to the time when they were hurt. But there's a bit of a scientific portion of it too. So in a personal injury case, the independent medical examiner drafts a report, and they either say, yes, the person is permanently injured, or they're not. In the workers' compensation system in New Jersey, it's actually far more complicated, to where the expert puts a numeric assessment of disability in the report. So in addition to what Victor does and what Bill does on the artistic side of being able to present the case and tell the story to the judge of compensation, I also want to make sure that I have a report on the scientific side to where the doctor reviews all of the correct records and that the doctor's numeric assessment is in line with the injury that the client has. You have to make sure that you hire an expert that writes a quality report and will assign a number that reflects the damage your client has suffered.
Do you still see, Bill, the defense doctors? Now, I haven't done workers' comp in 30 years, but when I was doing it, you get a defense report that would say, from the IMA, would say, oh, they're 2.5% of partial permanent disability, and your doctor's got them at 32.5%. Does that still happen?
All the time. And to answer that, and also to segue from what Mike just said too, and I'm glad he said it. I haven't got a decision from a judge on this case yet, but I did try a case recently. Took the guy's testimony, took medical testimony. My doctor says my guy's condition is 80. I'm making up a number, but it's around there because it's a big case. Their doctor has a 10. So that's a big difference, right?
Sure.
So following what Mike said, the effect that this accident had on my client was that my client was working for the Department of Public Works for town, had a pension because he was already vested. He did about 11 years, let's say. But if he did 4 more years, it all translated into him losing money. The guy's losing money every month because his pension would have been higher had he been able to finish at the Department of Public Works for that particular town. He had to change his job because he wasn't able to do the physical work that he had to do at that job. Okay, that's very real. He testified beautifully all about that, laid it all out. So he knew exactly how much money I'm losing per month because of this. So then when I took the doctor's testimony, and their doctor went to Harvard, I congratulated her. I told her I'd been to Harvard once to use their bathroom. But bright doctor, very good doctor. But I think she was new to this stuff and really wasn't used to. But she'll be perfect because, as I said, the number was 10, which is ridiculous. And what I do when that stuff comes up is I do a hypothetical. And I say to the doctor, I talk to the doctor about the fact that, do you really think it's just a 10 when I got a guy that testified beautifully, credibility is not an issue, and he had to change his job? And as a result of that change in occupation, he's taken a big pay cut every year. I'm going to see what the judge says, but I think I did a good job questioning that doctor. And I usually like to say to doctors, forget about this, your role here. Your role here was as a forensic expert commenting on a petitioner. Let's assume that the petitioner instead is your patient. Do you believe your patient when he tells you that he can't do this job anymore? Do you really think that the man with all these injuries, that you've seen all the MRIs, you've seen the surgical reports, do you think that doing this job is really something you're going to tell your patient he should do? And then usually you get, on cross-examination, you'll get answers from that doctor that'll probably support your claim and make the claim look a little more serious than the doctor's report had your person's condition looking.
Another nice tactic, too. So one of the things that I appreciate about our firm is the sheer size of the firm. For example, the 3 guys up here that handle workers' compensation cases have recovered over $400 million just in workers' compensation cases in the state of New Jersey. We have a lot of similarly situated cases. In turn, when you get a doctor that writes a low number in a report, we can comb through the database that we have at the firm and look for cases where the doctor drafted a similar report and assigned a much larger number. And my favorite thing to do is, have the doctor explain the number in the present case and then hit them with a report from 3 years earlier where they assigned twice as much, on a similar or almost identical injury. It puts the doctor in a very nebulous position, and because of the volume that we've handled over the years, we have a really great database built of reports from different doctors.
What do we do now? Just changing a little bit here. I talked earlier about people being afraid to file a claim of workers' comp because there's the threat of losing their job. How do you address that?
Well, to start with, we do have a very healthy ability to refer people to an employment attorney, and we have a referral department. We refer people to trusted employment firms and advise them of that. It's illegal to fire somebody for filing a workers' compensation case.
Under both state and federal law in New Jersey.
So at the very beginning when we talk to somebody, we advise them of that. We can't prevent an employer from doing something that's patently illegal, but we can put you in the hands of a really good law firm immediately that will defend your rights. And I think that kind of helps a bit. A lot of times when we talk about employment law, it's more, I'd say it's a little more nebulous, where we kind of say, look, an employer might start treating you differently. And on my end, it's advising clients, this is what you're going to need to do to start documenting these things. Document it immediately. Protect yourself immediately. So if it's something a little more insidious, it's a little more subtle, this is what you need to do, what you'll need to do to protect yourself if you need to go talk to an employment lawyer.
Sure. You guys all do the same thing?
I usually, what Victor said is spot on. I also tell clients that the guy that's threatening to fire you today because you got hurt is likely to threaten to fire you a month from now because he doesn't like the shirt you're wearing. And I've talked to a lot of male clients, and it's usually their wife that looks at the husband and says, this lawyer's got a point. You work for a dirtbag, and you've got a bad
Is
injury
that a legal
here.
term?
Well, that's just from the streets where I grew up. But I should clean this up. This is a podcast. I'm not used to. You have to forgive me. I'm not used to podcast conduct. I'll clean up my mouth. I'm sorry.
No, that's
my
fine.
apologies.
That's fine. It was just funny.
So at any rate, I have had clients that I say, look, if you sprained your ankle and you're going to be better in 3 days, don't jeopardize your job. If you've got a real injury, think about this. And usually they will think about it, If not that day, come back to me a week later and say, I want to do something about this, Mr. Grabler. And I am not one to file lawsuits, chase ambulances, all that stuff. But I do believe that people should consult lawyers quickly after accidents happen. The sooner the better. You should hear all your rights. I think it's very valuable. But I've had experience with clients that have come to me a year or two after an accident and didn't do anything because they were afraid they were going to get fired. And guess what? They got fired anyway. And some of them did get treatment, so I was able to salvage something for them, but some of them didn't. And they lost out, and they're not the same physically as they would have been, and they got no compensation for it because they were afraid. I respect the fear. I do. We all need to hold our jobs. I get it. Another thing that's cropped up recently in New Jersey is people who are afraid to file claims because of ICE. And I've actually visited Delaney Hall to have a client, sign settlement forms. And that's a very scary thing, too. Do I file a claim because I'm afraid that I don't have papers and something horrible may happen to me and I may get deported?
Right.
That's an even more serious conversation.
Yeah, and it's a very interesting conversation to have because the employer is knowingly hiring these people that are undocumented in the country. Mike, you have anything on this?
No, that's pretty much it.
Then I'll give you client management. We
Yeah.
talked a little bit just now about client management if they're afraid that they're going to be terminated from their employment. But what are some of the difficult conversations you have to have with some of the clients?
Absolutely. So in workers' compensation in New Jersey, there's a matrix or a chart, essentially, that documents how much each body part is worth.
I always found that amazing.
Right. And some of the body parts are worth a lot of money, other ones are not. For example, and the chart dictates not only how much the body part is worth, but the parameters of the body part. For example, if I hurt myself here, no one would say this is Mike's hand, but the chart says it's a hand. So there are times where I'll have a client comes in and their hand is midway amputated straight through the forearm, as if it got hit by a circular saw. And you've got to explain to them that, the injury is only worth $250,000 because the chart says that's what it's worth. So one of the things is if the client has injured a body part that the chart assigns little value to, you have to be honest with them and set realistic expectations on day one. This way they can kind of gauge what they do for income going forward, how they're going to survive until the case resolves. So the first thing I would say, set realistic expectations early on. It's easier to do in a workers' compensation case than in a traditional personal injury case like an auto accident or a trucking accident. The second thing is you've got to send the clients to treatment right away, and you have to be able to explain to them what the treatment is going to entail. At the end of the day, the clients have to help themselves. We can send them to a doctor, but they have to go, they have to get the treatment, they have to take the treatment seriously, and certainly after we have the diagnostics, if we're going to start sending them to specialists, we expect them to be on time, to take the medication that's recommended to them, to perform the at-home exercises. So I like to tell them that, one, you've got to comply with the treatment, and you've got to be able to help yourself. We will schedule you for treatment. We will do everything in our power to make you better, but you have to take it seriously. And then also, I'd like to tell the clients at the beginning, too, the time frame. Some cases are very straightforward. An easy case, I have it done in 4 months, 6 months. And I'll tell them right at the beginning, I can get a couple $1,000s, not a huge value case, and I'll get it for you within a month or two. It's not going to take particularly long. Then there are others that I have that are serious, significant injuries, hundreds of thousands of dollars. Those, you've got to be honest with the person, it's going to be a long process. Here's what you can expect not only in terms of treatment, but in terms of time on the case.
No, I think that's very important. I always stress that in the personal injury department to set expectations right in the front. Unlike workers' comp, we're forced, if you file a case, with a year of discovery. So, people, it's going to take, if you have to file a lawsuit, you're looking at, an additional 2 years at least on the case if you can't resolve it. And we all know that insurance companies do not want to resolve cases early for full value. So you have to really be honest with your clients and set the expectations. And if they know right up front, then you would never really have a problem client because you set those expectations. What are some of the hard conversations you have to have, Bill, with some clients?
First, I think, Mike, and you're right, set expectations is huge. The both of you said it. You're both right. What Mike said is accurate. I'll add one thing, and I had this difficult conversation with a client today. Wage. The awards are tied to how much money a person makes. Not always, but if it's a serious injury especially, we talk about the matrix, the chart, whatever we call it, a chart. I could have a person who's 50% disabled because of a serious back injury. And if that person is making $2,000 a week, the injury is worth X. I could have a person making a very low wage. The injury is now worth 1/10 of X. That's a tough conversation. I had it today. I have a woman who I worked out a settlement where she's getting total disability, can't do any better than that. Not happy. Excruciatingly long conversation today with a client, and I get it. And but the wage is a big issue. Sure. Wage affects the amounts of the recovery. Also, in New Jersey, you get workers' compensation as permanent disability. That's it. Again, part of the conversation today was your kids are not getting money out of this. You are not getting money for lost wages. You are not getting money for pain and suffering. Those were all things that I talked about at the inception of the case to temper the expectations. But as often happens, as time goes by, that conversation gets forgotten.
Right.
But I would add those things as leading to difficult conversations.
How about you? Anything else you want to add?
I think the really kind of hard one is kind of dovetailing on that case would probably be the one that you have where serious injury where someone is sitting on or is collecting temporary disability for a very long time, excess of a year, year and a half. And as they approach or hit maximum medical improvement, if you have an injury where they're not just going to be physically able to go back to their new job, you've been surviving on temporary disability 70% for a long time. It's been hard. Temp is going to end. You're going to go to zero. And I am not going to be able to settle your case for a period of time, right? It's going to take time to set up those IMEs, to exchange those reports, to negotiate and settle your case. During that time, I am not going to be able to provide money from you from the case. I am not a source of money for you for the case. And if you are not able to return back to your prior job, I try to get ahead of those cases and go, you have to start thinking about what you are going to do for work. It is not an easy conversation because I'm trying to tell somebody that may not be able to be that competitive in the workplace, like somebody that may be doing a physical labor job that really can't do that and maybe can't work a sedentary job or like a knowledge job. Like, hey, you got to go do the impossible. Oh, and by the way, because you've been on temp for a year and a half, you're not going to be eligible for unemployment. All I'm doing is just sort of warning you of the cliff that's coming a month or two ahead for you. It doesn't make navigating that a whole lot easier. Right. But that is not an easy conversation. I have it once every month. I don't have an easy answer for that person. That's just kind of how our system works.
Yeah, the one thing that everybody should understand that for workers' comp, if you're injured on the job, you have a claim. If you're working and you're injured, you have a claim, even if it's your own negligence. I once had a client looking at a beautiful woman in the summertime working on a table saw and cut off 3 fingers. He was at fault, but because he was working, he could still file a claim. When you're filing a third-party case, someone else has to be negligent in order for you to file a claim. Also, the one thing I think is very important is for people to know that if you are in that automobile accident that you were talking about and you're working at the time, that your workers' comp insurance is primary. If you're injured on the job, your workers' comp insurance is primary, then it would be your automobile coverage, then it would be your health insurance. So before we conclude today, talk a little bit about why somebody who's injured on the job should hire you or GGL, Victor.
Because we win. We're the best. Just, I mean, because honestly, we're the best firm in the state. I mean, just top to bottom, our attorneys are just genuinely the best, top to bottom. Our staff, our systems, just the whole approach, we're just great. And I will say this as somebody that joined the firm in 2021, I can tell you, and I think I told you this like a couple of, weeks ago. I can tell you that just sort of like my knowledge, my skill set, I'm a heck of a lot better at this than I was when I started here. And I think that kind of like knowledge and growth and skill set for me personally, I feel like that's kind of like a common growth trajectory of like other people that have joined the firm. And I think that's also true of kind of like staff members and our paralegals. You just learn a lot, and it's just being exposed to people like Mike and Bill, just people that know their stuff in an exceedingly high level. It's osmosis. So, there's just no other firm that I would trust more than GGL for the injured worker in the state of New Jersey.
Yeah, it's amazing how good a comp lawyer Bill Grabler is. When people ask me, I say he's probably, without a doubt, the best workers' comp lawyer in the state. And he has some great proteges that he's mentored that were very, very good comp lawyers before they came here. But I think they are now also some of the best in New Jersey through Bill's tutelage and their just pure diligence and tenacity in the workers' comp industry. So I'm proud to have all these guys on the GGL team. Why should they come to GGL, Michael?
We've got a couple of reasons. Number one, we cover every county in the state. We have 12 offices. They're sizable offices. They're fully staffed. You can live anywhere here, and we can represent you adequately. The three people on the stage here that handle workers' compensation, we represent a fraction of the department, not the firm, fraction of the workers' compensation department. We've recovered over $400 million between the three of us just in workers' compensation cases. When people go out and they look to hire a lawyer, they should go and inquire, how big is the department? How many offices do you have? How much have you won? When you look at those things, the choice is inevitable. GGL wins. Now, putting that aside, we're also the firm that has pioneered the idea of forwarding people for medical treatment in denied cases. By far, not even close, more than any other firm, we have pioneered that. So you have a claim, whether it's an accepted claim or a denied claim, we have the staff, we have the office location, we have the team, we've got the money to bankroll a big case if need be, we have the correct experts. We have everything here that someone needs to win.
And now, Bill?
I love hearing everything I just heard, and it's all true. I hired these two guys myself, and nobody works at this firm unless they come through me. I'm not going to let anybody come onto this workers' comp team without me seeing them and giving them a stamp of approval. And I have not hired people before and worked tremendously harder than I really needed to, because I wasn't ready to put somebody on my roster that I didn't think was up to snuff. I'll work twice as hard as I have to rather than hire an incompetent person. And unfortunately, in the state of New Jersey, you're going to look at a lot of law firms that have, and I don't like talking like this, but I am going to say it because it's the truth. There's a lot of mediocrity out there. And it knows, believe me, I'm 67 years old. I hear older people talk about younger people and badmouth that generation because they're not hard workers. That's BS. There's old people that are horrible workers. There's young people that are horrible workers. Being a horrible worker, being a lazy person, it doesn't matter how old you are. That could be anybody. But we go way out of our way to hire the right people here. This team that we've got right now, it's as good as any team I've ever had here in all my years. I'm proud of all these two guys here. I'm really proud of, and I'm really proud of the team that we've got at GGL. The other thing is this. I'm 67 years old. I was up till 12:30 last night looking at a file because I had to meet somebody today and talk to her. There was no way I was going to talk to that person without knowing her file like the back of my hand. That's how I am. And that's how these guys are, and that's how we are at my firm. We will outwork everybody. I could say that with all honesty to you. We outwork everybody. The last thing I'll say is we actually like what we do. I'm not going to stay up till 12:30 looking at a file unless I'm liking what I do, unless it means something to me. It's a matter of pride for me. I'm in my house on my computer at 11 o'clock at night. I may send an email to Mike and Victor, and I get responses. And I've got other people at the firm that are the same way. We're all crazy, I guess, because who works the hours we work? People that really like what they're doing, people that take great pride in what they're doing, and people who like helping people. It's all about helping people. And I'll say that about the lawyers. They already talked about the staff. Our staff is great. It's a staff of really good, hardworking people who try to be as nice and decent as they can to people who need help, who may be stressed out, totally stressed out, given the situations that they're in because of work-related injuries. So between the lawyers and the staff, we all team together because it's a team. And I think we do a great job for the injured workers in New Jersey. And I'm proud of this law firm.
GGL, the authority in personal injury. I want to thank 3 of our top workers' comp lawyers here. Not all of our workers' comp lawyers because they couldn't fit at the table, but Victor Broccoli, Mike Tomasino, and my partner Bill Grabler. So if you're looking for the authority in workers' compensation and personal injury, you look at GGL because GGL wins and we win for you. Thank you.